Mr. Self.
Ladies and gentlemen of the jury, this is the most solemn phase of any proceeding in our system of justice. You've already carried out your duty determining the guilt of our client in this case, and now the law asks you something even more difficult to do. Decide whether or not to recommend whether a human being should live or die. This is not a decision about what happened, it's a decision about what should happen next. In Florida, the law is clear. Before you can recommend death, the state must prove the aggravating factors are so weighty and so compelling that they outweigh all mitigation, and that death is the appropriate and just punishment. If even one of you, after careful consideration, believes that life is an appropriate sentence, then your voice matters. Your oath matters. Let's talk for just a second about the aggravating factors that Mr. Buxman just talked to you about in closing argument. And we're going to rely on some of the evidence that was talked about in the guilt phase, obviously, in this case. But I'm going to address the second factor, the heinous, or the first one that he talked about, which I think was the second one that they put on evidence about. But with regard to heinous, atrocious, and cruel. We believe that you will be provided jury instructions. So between the two areas that I've marked on this page, that talk about first-degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of or the suffering of others. Leave this here for just a second while. The state has argued that the killing was heinous, atrocious, or cruel. Those are powerful words. Words meant to evoke something beyond the already terrible reality of a homicide. But not every tragic death meets that legal standard. The law requires something more. The law requires that heinous be extremely wicked or shockingly evil. Atrocious be outrageously wicked or vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even the enjoyment or suffering of others. Well, the state would have you believe the worst possible story. In the guilt phase of this case, you weren't asked to determine whether the factors that went into how this first-degree murder happened. You were presented evidence, and the state has put together their version of the worst possible story. They would have you believe that there was this drunken party and that Mr. Hunter and Miss Green went back into the apartment and had a fight or had a struggle, which is that there's utterly zero evidence with regard to any of that. There's zero evidence with regard to how the hole got into the wall. You may have heard a lawyer argue at one point, I think Mr. Nunnerly may have argued that that may have been a shoulder in some sort of fight or dispute or disagreement with Mr. Hunter. If you look at the height of that hole, the height of that hole is specific to where the bathroom door catch is. And there are photographs that are placed into evidence that suggest that it starts at about 24 inches off of the bottom of the ground and goes to about 36 inches off of the ground, which is right about where the door handle catches into the bathroom, which is right about the same level as somebody's bottom or backside right? It's not the height of the shoulder. Miss Green was 5'5" tall, which is over 60 inches. If you discount the height of her head, which is another foot, then you're talking about to be shoulder height to be pushed into the wall would have to have been somewhere between 45 inches and 55 inches high up onto the wall. There's no evidence that Theresa Green was ever pushed into that wall. There's no evidence that Mr. Hunter was pushed into that wall. There's no evidence that Mr. Hunter was in the apartment in the first place, with the exception of his DNA on the blood on the watch. Now, what's more likely, using your common sense, did the watch get broken when Theresa Green fell and tumbled down 14 steps from the top to the bottom? Or during some fictitious argument for which there is no evidence that a watch was broken during an argument? It makes no sense. It defies common sense. So this version of stringing together a hole in the wall and a broken watch, there's absolutely no evidence with regard to any of the state's theory about heinous, atrocious, or cruel. You heard or saw the medical examiners, both Dr. Utz and Dr. Arden, testify with regard to the photographs that were shown. Both agree that there is some sort of hematoma or bruise on the back of her neck. Again, what's more likely that hematoma or bruise occurred during a fall and a tumble down 14 steps? They both indicated that they did not believe that had anything to do with strangulation or evidence of strangulation. Once again, there's no evidence of Mr. Hunter's DNA or fingerprints on the body. There's no evidence of Mr. Hunter's DNA underneath Miss Green's fingernails. There's no evidence of her own DNA underneath her fingernails, meaning that whatever the state's version of the scratch marks, and there were numerous of them, far more than 4 fingers. Does someone have 10 fingers on a hand that would cause that? Or is it more likely that scratching that took place there was a result of a tumble or a fall down 14 stairs over carpet, over concrete, to the bottom landing? Or, as Dr. Arden testified, he believed that was evidence of slippage, the skin slippage, because of the way that the body was placed into the trunk and the pressure, as you see the photographs of her face have climbed, some of the slippage of the skin in that location, that also occurred on that side or that portion of the neck. And Dr. Arden testified that he did not believe that any of the other evidence in the surrounding areas would support evidence of strangulation. Dr. Utz agreed that it could have been from a fabric, could have been from some other abrasion, but it was his ultimate opinion that he believed that there was evidence of strangulation. We don't believe that there's any evidence of heinous, atrocious, and cruel. Going back to Miss Green's blood alcohol level, it's very important to understand that at a 0.288, there was testimony by Dr. Arden, I believe Dr. Utz may have agreed with this, that the fermentation process that may have taken place doesn't always take place, and they actually have no evidence of it taking place in this case, but that could attribute an additional 0.08 to someone's blood alcohol level. So at the 0.288, we're talking about going to this is math, sorry, but into the tenths, right? The sort of second digit after the decimal place, that 0.08 could have been added. So if you subtracted that out, her blood alcohol still would have been a 0.20, which would have been more than double the legal limit to drive. She clearly was intoxicated. She was clearly intoxicated based on what Mr. Butler testified to. Her drinking, she was drinking Captain Morgan's, and she had been drinking. She drank a whole bottle. Her behavior would suggest that she had been drinking and that she was intoxicated. She slapped Mr. Butler on the way out. She got into an argument. She tumbled down the stairs. All of that is evidence of intoxication. The medical examiners cannot tell you how long it took Ms. Green to die by strangulation. Dr. Utz and Dr. Arden said it could take seconds, it could take minutes. They don't know. And there's no evidence in this case of how long it took her to pass away. We would suggest that there's no evidence that the state has not proved beyond a reasonable doubt the evidence of heinous, atrocious, and cruel. All death is sad, and all death is terrible. But all death is not heinous, atrocious, and cruel. In jury selection, we talked about a sort of special subset of all first-degree premeditated murders, right? Killing an innocent person by an individual, not because they're crazy or self-defense or any of those reasons. And there was a reason that we asked you those questions, right? And all of you swore that you could follow the law and follow your oath as jurors, and that you would agree that, as the state mentioned in their closing argument, that if you got the opportunity or you believe that the aggravating factors outweighed the mitigating factors, and after careful consideration, even knowing that you don't ever have to come back with a verdict in favor of death, that you could. So the possibility that you could do that. You also swore the same to us, or talked about being able to do that as well. So that if the aggravators, even if the aggravators outweighed the mitigators, you still could consider all of the mitigators and give it meaningful consideration, and you still could come back with a life verdict. So we all stand before you on even footing, asking you to take a look at the actual evidence, not a narrative spun by the state to make Mr. Hunter look like a monster. This is not about trying to demonize an individual so it makes it easier to kill him. This is about looking at the actual evidence in this case and trying to reach a determination about whether or not Ms. Green died in a way that was heinous, atrocious, and cruel. We do not believe that the state has proved that based on all of the actual evidence in this case. Let's talk about the second factor. The second factor was Mr. Hunter's past. These judgments and sentences. And the state argued to you that he's been convicted of 5 prior violent felonies, and that 3 people have been indicted. But he showed you in that 4 of those 5 circumstances all took place in 1985. January and February and ultimately March of 1985. Mr. Hunter was 18 years old in Oakland, California at the time all of those incidents took place. By the way, all of those incidents took place with a firearm. Even the later murder in 2002 took place with a firearm. And obviously, in this case, we're not talking about a firearm. So there's no similarities, there's no consistency of that. Mr. Hunter's not a monster who goes around shooting people randomly. We don't know what the facts, obviously, of the 1985 case are specifically. We did not hear any evidence from Assistant District Attorney Bruhard that Mr. Hunter was in a gang. He was a gang prosecutor in Alameda County for a long time. He would have provided that information if that were relevant or pertinent. So we don't know what those circumstances are when he was 18 years old and got himself in a series of trouble in those months in 1985. We did hear a little bit more about the circumstances in 2002 involving the friend of his wife that was shot under those circumstances. But I ask you, why are we judging an individual by the worst 4 or 5 days of his life, as opposed to what we tried to attempt to do in the penalty phase, which is to present individuals from Mr. Hunter's past who know him. They know him on mundane days. the 7th grade days, the 9th grade days, the 10th grade days, the after high school days, when he has a child and a baby in this world. All of those days, if you look at the Alexanders who lived in New Mexico, if you look at his best friend Sherman Alexander, if you look at the Long sisters who he went to school with and how he knew them afterwards, they've known Mr. Hunter for years collectively. And we tried to present a side to him to show you that he's not a monster. The state's trying to say he is. And we're trying to say, but the people that know him best for all of this time, that they're saying he's not. That's not how he is. He cared very much for the Longs and took care of them when he went to school with them. He made sure that they went to school, that they did their homework, that they got lunches when they couldn't afford it. He took care of their mother. He was respectful. He was respectful to the Alexanders. He came over to their house. He rode bikes and mini bikes and dirt bikes and things like that with his friend Sherman. And he was, for all intents and purposes, a normal kid growing up in Oakland, California. And then in the 80s, things get violent in Oakland. Things take a turn for the worse. The state would have you believe that just because Sherman came out of it without a felony conviction, that he's somehow a successful product of Oakland, California. We would argue to you that Sherman had been shot during his youth in Oakland, and maybe that had some impact on what happened in 1985 with Mr. Hunter in terms of the violence that was taking place in California. And maybe that had an impact on him. Remember, at the end of this case, your decision is going to be between a recommendation of life without the possibility of parole and a death sentence. And what we're trying to say is that, according to the law, life without the possibility of parole is a valid decision and a valid sentence that punishes Mr. Hunter for his actions in this case. He's not a monster. He's not a monster that needs to be put down. We don't need to light torches and create pitchforks, sharpen our pitchforks, because the penalty is going to be appropriate either way. But what we're trying to argue is that there is this other side to him, a human side to him, a friend, a person who cared about the people in his life. You also heard from the Butlers and Lisa Moore and even Octavius Hayes that up until this incident, they never witnessed Mr. Hunter ever be violent or aggressive or angry in any way, shape, or form towards Miss Green. So Mr. Hunter isn't. And so when you have to make the decision as to how much weight to give to the aggravators versus the mitigation in this case, I would argue to you that judging a man by his 2 worst days, and I'm going to lump those 4 events from January to March as one series of events. But basically, we're talking about two days of his life. 4 days if you actually count them individually. But weighing that against a lifetime of being a good friend, a good son, a good father to his child who he's never seen outside the walls of a prison, still maintains a relationship with her, still corresponds with her, corresponds with his granddaughter. So he is human. the things you're going to be asked to do after you make your determination about the state's aggravating factors and whether they've been proved beyond a reasonable doubt. Again, it's the defense's position that they have not proved heinous, atrocious, or cruel beyond a reasonable doubt. Is you're going to then be asked about the mitigators. And the mitigating circumstances in this case that we believe the defense has showed you is that Demorris Hunter grew up in a violent neighborhood in Oakland, California, where he had to learn to protect himself and others. That Demorris Hunter was generous and kind to his friends and family. And that Demorris Hunter was protective of his friends and family and tried to keep them safe and out of trouble. That Demorris Hunter was respectful and obedient to his elders. Demorris Hunter was a loving and attentive father to his daughter, the relationship that they have. Demorris Hunter earned the love and affection of his friends and family who love him still. And the existence of any other factors in the defendant's background not mentioned above that would mitigate the imposition of a death penalty. Remember, mitigating circumstances can be anything we've said or done or emphasized, or anything at all, anything that you've heard that you believe is important. And ultimately, again, the state's going to, as the state talked about in their closing, they're going to ask you to weigh the aggravating factors and the mitigating circumstances. And I would argue to you that the mitigating circumstances, the evidence of his life, right, every day, all of those days, even the mundane stuff, who Demorris Hunter really is, clearly outweighs his worst day, the prior convictions. And again, even after this weighing process, regardless of the results of each juror's individual weighing process, even if you conclude the sufficient aggravators outweigh the mitigators, the law neither compels nor requires you to recommend that the defendant should be sentenced to death. As we talked about in jury selection, each one of you gets to put on your little robes and make decisions about this case. And all of your decisions individually are important. We talked about how no one would bully someone out of their position and that others would try to protect people who were being bullied out of that. If one of you believes that life is the appropriate sentence, then that is your decision, and your decision and that decision is perfectly lawful pursuant to these instructions. Respect that moral process, respect your moral decision, respect others' moral decisions, and record that vote. A sentence of life imprisonment is not mercy without consequence. It is accountability. It is punishment. It means he'll spend the rest of his life in a prison cell and he'll never be free again. It protects society. It ensures that he will never harm anyone outside those walls. But it also leaves room for something else. The recognition that human beings are more than their worst thing that they've ever done. I know sometimes in closing arguments I sit here and I think to myself, and I think you'll hear a jury, part of the jury instruction will say that if the lawyers have done anything, that you shouldn't hold it against our client. I heard my voice on the Alexander's video depots from New Mexico, and it drives me crazy whenever I hear my own voice on video. And so if you think that we have said or done something, either Mr. Marrero or myself, please don't hold it against Mr. Hunter, our client. Hold it against me, okay? But as lawyers, obviously we have jobs to do, and we advocate on behalf of our clients. Sometimes I think I struggle for the right words to say in closing arguments, that I'm trying to be super convincing, the best possible version of myself. But I want to read to you some quotes from others that talk about death penalty cases. And I think it's important to hear the perspective of others. Martin Luther King Jr. once said, "Returning hate for hate multiplies hate, adding deeper darkness to the night already devoid of stars."
At this point, can we approach?
You may. The objection sustained.
The state needs 8 votes for death, but the law also requires the power of one conscience, one voice, one juror who says, "I've heard everything, I've weighed everything, and I cannot say death is the appropriate sentence." If you are that juror, if there is any hesitation, any doubt about whether death is just and necessary outcome, then the law does not ask you to set that aside. It asks you to honor it. This is not a decision you can undo. No second chance to reconsider. So I ask you to look at the evidence carefully, to weigh not just the aggravation, but the mitigation, to consider not just the crime, but the person, to recognize that even in the darkest circumstances, the law allows for life. And if after doing that, even one of you believes that the sentence of life is the right sentence, then you must stand by that belief. Because in this moment, your judgment is not just permitted, it is required.